Oop, I gotta shut mine off too.
Well, I like the sound of that one.
7. on
Mine
the
just
nose.
blows my eardrums out. I think it's close enough to 7 to say
It
it's
is
7.
7.
It's 7.
Okay, welcome to the Lunenburg Zoning Board of Appeals. What I'd like to do is tell you how we run the operation here. What we do is we welcome you, and we ask Lisa if she'd be so kind as to read the applicant, the application, and then if you should like to speak to it, you don't have to, but you could if you should like to. Seeing you have an attorney, I suspect there'll be some correspondence. So that takes care of that. Then we open it up to public discussion for those who may favor or do not favor the application. And we cut off public discussion, and then the board takes it for deliberation and take it to the end point. And with that, Lisa, would you please?
This was originally an application for a variance and was received and filed by the town clerk on December 26th of 2013, but was amended on January 22nd. So this is an application for a special permit for dimensional variation. The name and address of the applicants are David B. and Diane T. Meisner of 49 Jocelyn Street. The undersigned hereby petitions as follows. For a special permit to vary the dimensional regulations, area and frontage for previously grandfathered residential building lot. The lot contains 8,211 square feet and has 85 feet of frontage. The proposed action has not begun. The basis for this application for special permit for dimensional variation is found in the following section of the Lunenburg zoning bylaw, section 8321B4. The street address of the property is 51 Jocelyn Street, assessors map 97, parcel 4. The name and address of each holder of legal title to the land which is the subject of this case is David B. and Diane T. Meisner. The deed is recorded in Worcester Northern District Registry of Deeds, Book 6021, page 92, and recorded February 13th, 2006. And it was signed December 9th, 2013 by Diane and David Meisner of 49 Jocelyn Street. Attachment to petition of David and Diane Meisner. 11A, lot is an undeveloped portion of the lots established on the September 1, 1922 plan of Whalum Downs. It is abutted on its northerly side by the unimproved terminus of Burke Street. B, tax title lot was purchased in 2003 from Lunenburg for $81,000 with the applicant's abutting property at 49 Jocelyn Street placed in a realty trust to protect the Chapter 40A, Section 6 single lot exemption. The applicants changed the ownership of 49 Jocelyn Street in 2006 to secure financing on their newly constructed home, and inadvertently voided the protected status of the lot. Without the protected status, the lot is valueless. C, the lot is of similar size and shape to other neighborhood lots. D, but for the inadvertent consequence of a 2006 financially required decision, the lot would be a grandfathered lot. It was never the intention of the applicants or Lunenburg to have the lot treated as other than a separate lot. Attached is a plan of the land on the corner of Burke and Jocelyn. There is a copy of the deed from 2003 from the town of Lunenburg to David B. and Diane Meisner for the $81,000. There are 2 letters from the building official. Shall I read those, Mr. Chairman?
Say again?
Shall I read the building inspector's 2 letters?
Yes, I think they're germane.
Okay, I'll read the October 2nd one first. October 2 of 2013 to Diane Meisner of 49 Jocelyn Street. Dear Diane, please be advised that I have reviewed the documents that you have submitted to me for a determination as to the grandfathering zoning status of 51 Jocelyn Street as a compliant grandfathered non-conforming lot under Mass General Laws, Chapter 48, Section 6. After reviewing the documents, I concur with your attorney's opinion that the lot was never held in common ownership with your current house lot located at 49 Jocelyn Street. The declaration of trust that you are the sole benefactor of protects the lot at 51 Jocelyn Street that was purchased by your husband and yourself as tenants by the entirety. The dates of the declaration of trust and the date of the purchase of the lot from the town also substantiates the protection. Therefore, it is my determination that the lot has not been held in common ownership with your abutting lot and remains a single lot with the 40A protection as a buildable lot for yourself or another purchaser. This protection is for the zoning status of the lot. You must comply with other departments and regulations to obtain a building permit. My determination relative to my letter to David, dated March 19, 2003, was prior to realizing that a trust was formed before the purchase of 51 Jocelyn Street. This determination supersedes that determination. Respectfully, Michael Savageau from the Lunenburg Building Department. On November 12, 2013, there was another letter to Diane Meisner. Please be advised that it has been brought to my attention that the 49 Jocelyn Street Realty Trust that you were the sole benefactor of recorded on March 31, 2003, was sold back to you and your husband as tenants by the entirety on February 13, 2006. This transfer of the trust has merged 51 Jocelyn Street with 49 Jocelyn Street as of that date. A recent letter and documentation that you had submitted to my office referenced the trust being recorded on March 31, 2003. There was no information submitted, nor was there any reference to the transfer of the trust back to you and your husband in your attorney's letter dated September 23, 2013. Due to the evidence of the trust transfer in 2006, I must void my zoning determination in my letter to you dated October 2, 2013, stating that the lot had not merged, and restate based on the new information found that 51 and 49 Jocelyn Street have merged for zoning purposes. Therefore, 51 Jocelyn Street is no longer considered a buildable lot for zoning purposes under the common lot merger doctrine. If you have any questions in regard to this new zoning determination, please feel free to contact me at your convenience, and that was sent certified mail on November 12th. And there's a letter from the attorney, September 23rd, 2013, to whom it may concern regarding 49 Jocelyn Street Realty Trust. Attached, please find a copy of the Schedule of Beneficiaries executed March 28, 2013 by Diane Meisner, beneficiary, and David Meisner, trustee of the 49 Jocelyn Street Realty Trust. This schedule of beneficiaries clearly shows that Diane T. Meisner is the sole beneficiary of this realty trust, and that therefore it is not held in common ownership with the adjacent property, which is held by David Meisner and Diane Meisner as tenants by the entirety. Please do not hesitate to contact me should you have any questions regarding this matter. And that was signed by Robert L. Rice, Jr., attorney at Ward, Walsh, and Rice, P.C. in Fitchburg. There's an amendment to the purchase and sale. There's a purchase and sale for the property at 51 Jocelyn Street from David B. and Diane T. Meisner to Traditional Concepts, Inc., and signed by Carrie Ann Carlson, David Meisner, and Diane T. Meisner.
I would suggest that you read just that one page with item 1 and item 2 because it puts things in perspective.
Okay, the purchase and sale agreement dated October 15, 2013 is hereby amended as follows. 1, due to determination that the property is not considered a building lot, the performance date is extended from November 12, 2013 to 30 days after receipt of a final favorable zoning decision or April 1, 2014, whichever occurs sooner. 2, the seller shall bear all expenses for bringing the case before the Lunenburg Zoning Board of Appeals. In all other respects, the original purchase and sale agreement is hereby ratified and confirmed. This amendment is executed in duplicate, and it's signed by Carrie Ann Carlson of Traditional Concepts and witnessed by Diane T. and David B. Meisner.
I think we can just comment that the remainder, three pages on the document for completion, is the real estate purchase and sale agreement relative to the property, and I think that would satisfy.
Also, I received letters this evening from abutters through their attorney. November 21, 2013, this was submitted by Lillian Robertson of 3 Burke Street in Lunenburg. To whom it may concern, I have no objection to the construction of a new home at 51 Jocelyn Street in Lunenburg. I live alone. I would feel safer and more comfortable with a new neighbor close by. Sincerely, Lillian Robertson. November 20th, 2013, Michael DiMartino, 13 Burke Street in Lunenburg. To whom it may concern, I have no objection to the construction of a home on 51 Jocelyn Street in Lunenburg. I would consider it an asset to the neighborhood, and that's signed by Michael DiMartino II and Michael F. DiMartino Sr. November 20, 2013, Richard and Teresa Trank of 44 Otis Street. To whom it may concern, we have no objection to the construction of a single-family home at 51 Jocelyn Street in Lunenburg, signed Richard and Teresa Trank. November 21, 2013, Joe and Karen Slyman of 22 Jocelyn Street. To whom it may concern, we have no objections to the construction of a single-family home at 51 Jocelyn Street. Sincerely, Karen and Joe Slyman. That's all, Mr. Chairman.
Okay, thank you very much.
You're welcome.
Would the applicant like now to address the application to the board?
Yes, Mr. Bowen, I'd like to make a few remarks.
Name and address.
Attorney George
Even though
Watts.
we know you, we have to do it for the record.
Attorney George Watts' office is in Fitchburg. I'm representing the applicants tonight with respect to this petition before the board. Just a couple of comments before I begin. When Attorney Rice's letter was read by Ms. Normandin, she said that the Declaration of Trust was signed on a date in March in 2013. I believe if you look at the letter, you would find that the Declaration of Trust Schedule of Beneficial Interest was signed in 2003, which was the time that the trust was created in order to establish the grandfather status of 51 Jocelyn Street.
Would that letter represent a misstatement of the facts at the time?
No, I think
I
that...
read it incorrectly.
I believe that Ms. Norman just read...
Pardon?
She just read the wrong date, because I looked at the letter, it does say 2003.
2003.
Okay.
And that would be consistent with what I'm about to say relative to a bit of the history. I'm not going to go through all of the history. Attorney Rice is the one that prepared the initial submittal to the building inspector relative to the grandfather status. Attorney Rice had represented the Meisners in 2003 when they were dealing with the town of Lunenburg through a tax title to purchase 51 Jocelyn Street. And in order to protect the property, give it grandfathered status, this trust was set up in 2003 so that when they purchased the lot that we're talking about tonight for $81,000, it would have protected status. So at that point, we had a grandfathered lot that would have been eligible for a building permit. In 2006, the Meisners basically refinanced their house at 49 Jocelyn Street. They did not go back to Mr. Rice, who basically is an attorney familiar with real estate and obviously setting up trust, the significance of the trust. They basically refinanced their house through the Irwin Mortgage Company.
Pardon?
Through the Irwin Mortgage Company.
Yeah.
Went to a closing, were presented paperwork, and at that closing, they then signed the deed in 2006, which transferred 49 Jocelyn Street out of the trust into their names. The document was recorded at book 6021, page 92. Immediately following is the mortgage that is recorded at 6021, page 93. And I would just present these to Lisa. And the reason I'm presenting these, because in the application, you just said that the change in status of these lots was inadvertent. It was not an attempt to accomplish anything. They went to a financing of the property. They were presented documents. They signed them. They were put on the record in 2006 and forgotten. Basically, Attorney Rice, when he prepared the letter in October to the building commissioner, he knew that he had prepared the trust in 2003. He knew that there was a property in the trust. He knew there was a property on husband and wife. He wrote his letter accordingly. My client, and my true other client, who's the Traditional Concepts, they approached the water department basically to make sure that they could get water and sewer clearance.
Excuse me.
Yes.
Your client is whom?
My
there are
client-
other people here. You could be representing somebody I don't know.
No. You saw the purchase and sale agreement? Initially, I was hired by Traditional Concepts to assist in the purchase of this lot. When circumstances developed, as we are seeing tonight, basically, I was asked if I would step in on behalf of the Meisners to present this zoning case, because, as you know, I have been before this board before relative to zoning and planning matters. So my client, Mr. Carlson, on behalf of Traditional Concepts, approached the water department. The water department, just checking their records, made a determination of this deed change. And that was brought immediately to the building commissioner's attention, and he then sent up a follow-up letter. So again, my position on this entire thing is that the merger doctrine came into effect in 2006. We cannot deny that.
In other words, you take no issue with Mr. Savageau's rescinding of the...
No, absolutely not. He did the correct thing.
Okay.
But what we're here for tonight is we're looking for relief. And I would ask you to consider your bylaw, the section that we're here under for the special permit. There's nothing in that section of the bylaw that would preclude considering demergering. There's no line in there that says that this special permit for undersized lots only applies to conforming lots. Obviously, if they were conforming lots, they wouldn't need to have the special permit. So essentially, I would say that you have the power under your bylaw, under the section that we're now here on, the special permit section, that you could give the relief that we're looking for, that you don't have to stand by the strict language of the merger doctrine. And that's essentially what I'm asking, that you move away from strict application of the merger document and then consider this application on the basis of the special permit. These lots in that neighborhood for single-family construction, I believe it meets the requirement of the special permit section that I've quoted. That's my presentation.
Okay, thank you. There's two thoughts that come to me. I just give out the two thoughts to set the table for discussion. And it would seem to me that the issue at hand that we have here is Lot 51 is held in common ownership and merged with Lot 49 by the common lot merger doctrine. Therefore, the lot itself does not stand as an independent lot for consideration for a building permit. It would seem to me to be that. And my question is the petitioner requesting the board to reverse the merger imposed by the doctrine? In other words, the petitioner is coming and asking for a special permit for dimensional variation. And in my mind, it leaves me open. I say, well, what does that do to put the ship right? And how do you demerger? It seems to me that recognizing the lot, this board recognizing the lot for a special permit for dimensional variation, if you say, okay, I do it and I say it, doesn't break the coupling of the merger doctrine. And therefore, I'm having difficulty seeing where this board has the power to decouple the merger. In other words, as of this moment as we speak, it's merged. It is one lot. Am I right?
Well, I would say that the two lots have merged for zoning purposes. That is a correct statement. There are two tax bills. There are basically separate sewer connections to each lot. The merger doctrine, basically, yes, has taken effect. I don't believe I'm asking you to demerger the lots.
Do you think that that's the heart of my question?
Well, and again, I understand your question.
Okay.
And that's why I ended my presentation by saying, I believe if you look at the equities of the situation, the circumstances under which we are here tonight, I believe that this board could look at your bylaw and say there's nothing in that section that says you have to exclude merged lots, again, for zoning purposes. And I believe that you could grant relief to 51 Joslin Street by, in essence, not strictly applying the merger doctrine. That's what I'm asking for.
From a legal point of view, and this will be my last comment and turn it over to the board for what they have on their mind, but from a legal point of view, it's merged, and it would seem to me that it's merged forever. And for this board to break that, in other words, where is the power? I don't see where the power is in my mind, maybe not in yours or the members of the board, but it's germane to the discussion at least to say how, if it's merged, then there are documents needed to demerge it, to break the chain, to make them separate. Because they can't stand forever as a merged property and then graced to allow it to have a building permit. I think that I'll stop there, and that's laying the cards on the table.
Okay, well, and I appreciate your frankness.
Go ahead.
Obviously, they would be demerged if there was favorable action taken and the properties were then transferred to another party, so that you had 49 still owned by the Meisner's husband and wife, and you had 51 owned by Traditional Concepts. Clearly, that would create a merger. What would support the legality of that merger would be the action of this board. If this board granted the special permit, again, not strictly adhering to the merger doctrine. I'm not asking you to demerge. I'm basically saying your board has certain discretionary powers. Your ordinance does not exclude, under the section, the special permit section, does not exclude what I'm asking for. I believe you've got that power that's inferred in that section. That's a rather unusual section. I didn't even know that that was in your bylaw. That's why I requested a variance, and I was pleased that that was brought to my attention. I think that that's a powerful tool that you've got.
You're saying the special permit?
That special permit section in section
You see,
8 of your bylaw.
The special permit document was created because it is very difficult to grant a variance, very difficult. Matter of fact,
It's
unless for
impossible.
extraordinary circumstances could you ever do it. So, but it was created to give aid or assistance to someone who had an existing building and wanted to expand or grow on it and add or change, and then need some dimensional variations. And that seemed to be the correct vehicle for what it was in the purpose it was intended for.
Mr. Bowen?
This is extremely different and way out of the bounds of the purpose of intent of the bylaw as it was created, in the purpose to create it. And not to say that that's a problem, but that's the facts.
With due respect, I would say that you've got people who spent $81,000 to buy a building lot, and but for an act that wasn't really their responsibility, that they're losing the value of the investment. And I'm asking you to look at this provision that you said is intended to aid people, to aid the Meisners. So again, I think it all could come together that you've got the ability to take a favorable action.
Okay. All right. With that, I've set the table, and now to open it to the board for discussion.
You're
May
gonna
I
open
ask
it
for
to
further comment from the,
Pardon?
Further comments in
Further
favor
comment from the-
or against?
Oh, okay, yeah. I'm missing your point.
open it for further comments
Oh,
Public.
from the public.
no, I said if you wanted to ask a question
of the
right
attorney.
now,
Oh, I
of the
see.
attorney.
No, we'll wait till,
I haven't done that. If you want to add to my comments?
No.
Anybody want to add to the comments? Okay, that's what I just want to do. What we do now is we open it for public discussion for those anybody here who would be in favor of the petitioner's application. You give your name and address and say what you'd like. The petitioner doesn't have to do that if he doesn't want. but he can if he wants. If you got something to say, say it.
I always encourage the petitioner to speak their mind.
Good evening, gentlemen, lady. The intent was clearly an investment and to build a house. The economy turned, and it was a mistake to sign the at the closing. We just went through.
Yeah, could you speak just a little louder?
Yes, sir. A
Because
typical.
I don't have the sharpest ears in the world.
Okay, Bob. Thank you.
Thank
Donald,
you.
excuse me. It was our intention. It certainly wasn't our intention to take it out of trust. We did it at the closing, and it just slipped by, and it was an honest mistake. Diane and I are both lifelong Lunenburg residents, and I'd like a favorable decision, of course. That's why I'm here.
Okay,
Thank you.
thank you. Now we're on public discussion. Is there anybody here who would like to speak in favor? If so, give your name and address.
Steve DeBettencourt, 200 Pleasant Street, Honorable Board. I come to speak in favor of any consideration you can see to give this gentleman and his wife. I've known Dave lifelong, as long as I can remember back, and that's because I'm getting old too, you know, Don. I was sitting on the board when we sold this piece of property to him for $81,000. It was a good purchase. We put land back on the tax rolls for the town, and then if a favorable,
Probably
favorable
not,
can be seen in this.
not too much money on the thing. It's at $1,100, $17 a year.
Yeah,
Not bad,
I
but
mean,
that's money.
Yeah, it's money back on the tax roll, but it's also, I see it as a win-win. I know the neighborhood, it's not going to be unsightly to have another house on that corner to fill the lot in. And I also think it's a win-win for the town because we have another house. We always know what this town lives on, new revenues. Without the new revenues, we can't keep going. But new growth is always supportive to a neighborhood where it's not offensive. And I don't think it would be that in that neighborhood. So whatever consideration you can see to give this, my friend and his wife, I'd appreciate it. Thank you.
Okay, thank you, Steve. Anybody else would like to speak in favor? If not, anybody here would like to speak in opposition? And hearing none, we cut off public discussion and bring it to the board. Comments?
I would actually like to, I see that Mike is here. I would actually like him to comment on this if he has anything that he could add to this. I'm sorry.
You're guilty like I'm guilty.
I am. No, I see that Mike Savageau, the building inspector, is here. I know that he's written several letters in here, and I would just like to hear if he has any further comments on this.
Thank you, Mr. Chairman. Mike Savageau, building official, Town of Lunenburg, and zoning officer. I don't speak in favor and I don't speak opposed to the applicant's petition. Just a bearer of information. My first letter, Mr. Meisner had obtained a building permit for lot 49. And after when he did obtain that building permit, he did come to me at that time and wanted to be sure that it was a buildable lot before he purchased it. And at that time, he had shown me through Attorney Rice's letter back in 2003 that he had actually formed a trust. I did get a copy at that time of the trust that Diane was the sole benefactor, and I had made the determination prior to the purchase of that lot, the actual purchase of it, that it would be held in separate ownership, and therefore I gave him the original 2003 letter the day before he purchased. I think Mr. Meisner probably felt that that was going to secure his purchase for the intent that he had. So that was back in 2003. That was over 10 years ago. And I gave him that letter. When Mr. Meisner came in October of last year, he mentioned to me that he was considering selling the lot. And I had asked Mr. Meisner at that point, I said, well, you got to give me some more documentation because I have to make a determination as to the status of the lot again. And I said, look, why don't you get me a lawyer's letter stating whatever the opinion is of your lawyer. I do rely on those occasionally. And long story short, he came in, as was read for the record in October. I received a letter from Attorney Rice stating that the lots had not merged. This was October of last year, 10 years later. He stated that the lots had not merged, as Attorney Watts had mentioned, and so I took that letter, and I figured, well, the lawyer must know what he's doing. And at that point in time, I called Copeland and Page to make sure that I was making a proper determination, and I explained how Dave was the trustee and his wife was the sole benefactor, and that this was held in a trust, which I believed that, as the attorney must have believed, that it was still held in a trust since 2003. I made the determination, as the letter was read, that it was a grandfather lot under the Zoning Act of 1975, 40A, Section 6. And because I knew that they wanted to sell it to a builder, I expressed to them that they could also sell it to a builder. But it was only for zoning purposes, and you needed a sewer connection, you had to make sure there were no wetlands, there were other things that they would have to comply with, which they knew. And that's what happened. I got a phone call, maybe a week or two later, from Mr. Carlson, who was interested in purchasing the lot. I told Mr. Carlson, as I tell everyone that always wants to purchase a lot, not just for this specific case, but everyone, I said, well, make sure you make your agreement. It's up to you how you do it, but you need to get all of these signatures before I can release a building permit from these different departments. So you might want to make everything contingent, and again, I tell everyone this, contingent upon obtaining what you're trying to get. If you're trying to get a building permit from the building department, I don't know if that lot has technical wetlands that prohibit that. I can only tell you for zoning purposes. So make sure you structure it for your own protection. That's all I can tell you. If you buy the lot, you come to me and we find out that it's all wetlands, I can't give you a building permit, even though it's a standalone grandfathered lot. And he understood that, and he came in and got an application. He went around and he had all the departments sign off, as everyone does for a building permit. When he got to the sewer commission, Barbara, the administrative assistant, emailed me and asked me what was going on with the lot. And I said, well, I checked with Copeland and Page, and I have a letter in 2013 from the attorney saying that it had not merged. I saw that Diane was the benefactor when it was created in 2013. There was no evidence to me. Nothing was ever submitted to me other than the lawyer's letter and the benefactor and the statement of the trust. And there was never any mention to me that the trust had been sold back in 2006. Excuse me, so that when Barbara emailed me, I explained in an email back to her that everything was proper, and I checked with Copeland and Page, and this is why it's technically under 40A, a standalone lot, not held in common ownership. She told me when she was looking up at the registry of deeds, because when a sewer line goes by your property, you get a betterment, and those betterments need to be recorded. So apparently when she looked at the registry of deeds, she found that in 2006, and brought it to my attention that in 2006, as we heard tonight, the trust, for reasons that we didn't know at the time, we heard tonight the reasons why, the trust was transferred back to Dave and Diane as tenants in the entirety. My comment to that was, you gotta be kidding me. So what I did was I immediately went online, went to the registry of deeds, found that the trust in 2006 had been transferred back, And then I recanted my original letter in the second letter in November, saying that the lots had merged because the trust had been dissolved, and now that they had common ownership, that the common lot merger doctrine had merged the two lots. So that's kind of the history with Lot 49 and Lot 51.
Did you ask, call Copeland and Page again? Did you ask them about, now that they're merged, I mean, after they refiled, to find out what they feel about, because my concern is like Don, is how do you decouple, how do you demerge it? Did you ask?
No,
talk to them?
no, I only make my determinations, and the application was in front of me for the building permit, and I made the determination. I would have no need to ask them how to demerge it, because it's not my responsibility to see, to
Correct.
try to
I was
demerge
just
someone's lot that merges. I'm just the gatherer of information and making the determinations as the zoning officer.
Okay, thank you.
Thank you. Any further questions? Good news. To Mike while he's here?
Yeah, relative to the sewerage, if you can answer that. So there was no betterment paid when that occurred, if I'm correct, but they did put a T in or something for them to be able to connect to it.
I'm not aware that there is a sewer stub at 51. Is there a sewer connection at 51?
Well, it's proposed, it was never,
You have to get up
sorry, thank you.
together. The camera is big enough to get both of you.
I'm not running away from
The
it.
camera, great. No, I don't want to say this. At the auction, it was discussed whether the betterment would be charged, and because the sewer line was already run by the betterment, it was pretty much known that the town, that there was not going to be a betterment fee on the lot, because the sewer was already there. Okay. It's got this, this was the map in 2000, and it clearly shows I don't know if I can, it clearly shows that it had that it was proposed, 51 had a stub run to the property. Whether it was installed or not, I don't know.
They take care of it?
Well, I'd like to make
Go
a
ahead.
comment if I might.
Go ahead.
Relative to the sewer connections, I looked in the file for the properties along Jocelyn Street, and in 2001, a year before I was the building official, there was a sewer connection that in the town, whether they put a stub in or not, I wouldn't know, Jack would know that, but the town obviously would not charge themselves a betterment, and the town owned that property at the time. But there was a sewer connection that was made for Lot 49. That sewer connection was done back in around 2001 is when the sewer line ran in. So there was a stub that was put at Lot 49. I don't know if there's a stub at Lot 51. And there was some question at the time that the sewer stub was put in at 49 with the past building official who passed away, Roger Williams, if that lot itself was a grandfathered lot. And this was before my time. And then the sewer line was put in. At that time, Mr. Meisner came in and obtained a building permit for that lot, which is 49. That lot 49, and I think it's important that the board has a little bit of the history, but since you're asking questions about the situation over there, and we're talking about merger, Lot 49 actually was part of Lot 37, which up until this point in time, when I had to research for the board, Lot 37 was comprised of 5 separate small lots. And Lot 37 had merged, actually, probably, Lot 37 was the original house lot of the Meisners that was purchased from someone else. And when the persons before the Meisner purchased it, it had actually been demerged 1 or 2 times. And Lot 49 was represented to me back in 2003 to be a grandfathered lot. It was represented to be a grandfathered lot by Attorney Rice's letter, which was not anything relative to a trust at that time. And it was represented by an engineered plan that stated that it was also a grandfathered lot. And all that being said, in the fact that prior to myself becoming the building official, the town had put a sewer stub there. How that got there, I don't know. So I made a determination back in 2003 that it was a grandfathered lot because I was only presented a deed of lot 16 and 17, which represents the now 49, which is where the Meisners currently live. Never knowing at that time that the Meisners lived next door and had purchased 3 of 5 substandard lots that had already merged. So there was an owner or 2 prior to that those 5 lots had already merged. So there was a building permit obtained on 2 lots that was segmented out because, similar to some other situations we've seen in town, there were 2 separate deeds relative to 49 and 37 that had actually merged.
37,
37 is the house immediately preceding where the Meisners live now.
Right, I have some information, Ray, I can give you, you'll follow it. I got a few things.
Here it is. There's the 5 lots.
The one number 2 is 37. This one?
The blue one.
Yeah. It's 3 separate lots according
Yeah.
to the town.
And they were together, you're saying?
I want to share a couple of these. This is a chronology that I found at the Registry of Deeds.
All right, I pulled the same.
Yeah.
Yeah.
Okay,
This was the original Lot 37.
okay.
This
so-
was annexed off after they had merged to
So-
create 49.
So that was 37, then was lots,
13, 14, 15, 16, and 17.
Right.
That's clearer here.
This was the original Lot 37 that was merged and remerged a couple of times. You'll see the building for this.
Yep.
So, evidently so, I have to state that I wrongly issued a building permit at that time based on, which is in the packet, an engineered stamp plan from the Meisner's engineer stating that it was a grandfathered lot on the plan, and a lawyer's letter representing that it was a grandfathered lot, and the fact that it was, had a sewer stub to it. I could only assume at that time, after being 10 months into being the building official, that it's got to be a grandfathered lot.
So that you're suggesting that without the lots, apparently lots on this area here have merged and then forgotten about that they were merged and went off and recreated them.
There's been a cutting and pasting of probably 1, 2, 3, 4. There's been a cutting and pasting here of 9 lots, from lot 13 on the plan all the way down to, well, I would say 6 lots.
Okay.
But the fact of the matter is that all of that was done is actually currently protected by law.
Yeah, so for purposes of this hearing here, it's taken note of because the board asked for the information, but not necessarily germane to the decision process. that's in front
I
of us.
wrongly, based on the information that I was given at that time, issued a building permit for Lot 49, which actually was merged with Lot 37. But there was no representation, and there was quite the opposite, as you'll see in the packet, that the representation was by a lawyer and an engineer that those lots, that it was not a merged lot. At that time, I didn't even know the Meisners lived next door to the lot that they purchased. The Lot 49 was actually one of two deeds that the Meisners held that actually created Lot 37, that merged Lot 37.
Okay.
So he wrongly got the building permit, so be it. Chapter 40A protects zoning and building violations, provided you got a building permit from the authority, which is myself. And even though it was done wrongly, because all the evidence proved to me at that time that it had not merged, even an engineered stamp plan says it right on the plan that it had not merged, that I issued the permit, it had a sewer stub. There was a question a year before I was the building official, there was a question at that time if 49 should have had a stub, and that's in the file. That's a handwritten note to Roger, asking Roger to make a determination, but he was ill at the time. So a stub went in somehow before I was the building official, so I had no evidence otherwise, other than it was a grandfathered lot. But after 6 years for a building permit, and after 10 years for a zoning violation, it's protected by law. So for the purposes of this board tonight, I think you're just dealing, I think it's important that you know the history, but for the purposes of the board, a determination should be made relative to 49 and 51, because 49 is technically, in my opinion, protected.
Before we leave that, when the 5 lots that you said owned by other people were all contiguous to one, and you broke them, 2 were broken off, that seems to me to be an illegal subdivision, as you would might.
I would say
might look at
that,
it.
yeah, you're not supposed to do that.
But again, it's not for the purpose of.
But that's past history, and
That's history.
49's protected.
Thank you. Did he answered all the questions? Do you have further questions for Mike? Anybody?
Well, just so if I understand correctly, what you referred to as 37 included 5 lots on this plan, 1922 plan, right?
That's correct. If you read the chronology,
Yeah.
all the deeds represent that. It was actually merged and demerged before the Meisners even bought it.
Yeah.
And then it was demerged after they bought it. And probably unknowingly by the Meisners, and probably unknowingly by the individuals that demerged them. They had 2 separate deeds. They must have figured, and that, hey, I got 2 lots. I mean, they would probably have no idea that that there was a merger doctrine out there, because I can tell you this, I was the zoning officer for 10 months only, and I had no idea that there was such thing as a merger doctrine, until I gained knowledge.
Probably happened to a lot of people.
I would say probably happened in the past many, many times, 3 to 4 times just on that street alone with those lots.
But many people elsewhere.
Oh, yes, absolutely, absolutely. And it's my opinion, I don't think anybody did anything intentional, as Attorney Watts said. It just happened to happen.
Yeah.
And that's why there's protection for things like that, because things happen in error. And I can tell you, being the zoning official for 12 years, people don't know zoning. People do not know zoning until it kind of bites them in the butt. Whoa, as we found with Sky Cycle.
Okay.
Well, one of the things that strikes me about this is that, this is a whole development with lots which don't come close to complying with our current zoning requirements for frontage or area.
And that's why they all merged through 48, was
So that's what I was
because,
going to say. It seems like when they merged those 5 lots, it gave all kinds of frontage, met that requirement anyway.
right, back then, and there was no requirement back then. You'll see that that some of these individual lots don't even have
No.
5,000 square feet.
No.
3,900, 3,700.
Going to my opening remarks, it seems to me that notwithstanding the petitioner's request, that a Pandora's box is open that says that even in this area here, there are people here that could come forward and say, well, I didn't know, and I want to reconstitute, and I want to reconstitute and create new lots.
I actually have a letter from the
That could
people
happen.
that were the past
In other
owners.
words, as we look to the future, we'd have a parade of people coming in, creating new lots, and we sit here just breaking the common lot merger doctrine, which troubles me. See, that's what troubles me, is the legality of breaking, or our power to break the merger doctrine is problematic to me,
I-
because through the vehicle of dimensional variation, for
Well,
the creation of, it's a recreation of a lot. We don't, well, okay, I've said enough on that.
But
regard.
there is documentation in the file of one of these lots from neighbors that asked me in 2006. This happened in 2003. It's in the file, a handwritten letter, and I responded to them, and I told them, because they said, how come I can't separate my lots like the guy on the corner has 4 or 5 or 6 lots, and the person to the left of 35 has like 4 or 5 lots? But the person to the left never contacted me, but some people across the street, the prior owner and the new owner, more recently, the new owner last fall, wanted to know, because he had just purchased the house across the street, which is comprised of about 5 or 6 of those non-conforming lots, if he could annex some of them off and make another house lot. And I had to tell him no, as I told the Meisners, because they had merged. So there is requests from a neighbor, 2 neighbors that own the same property, to demerge their property, but I told them no. Now, they never came in to seek relief, and maybe their circumstances are different for the Meisners because they paid $81,000 from the town. I don't know if that comes into play. That's the board's determination to make. But, Mr. Chairman, what you state, I would have to say, is relatively accurate, that anybody can demerge a lot, I guess, if they come and get relief, and maybe that's what your board's here for under certain circumstances. And I'm not pro or con demerging a lot. That's up to the authority of the board if it so desires to do so.
But is that the venue to do it? In other words, to demerge lots, it would have to go to the creation of the merger doctrine and change the doctrine, which I don't think that this board has the power to change the merger doctrine.
I don't know.
That's what troubles me.
Right, as Mr. Gravel asked, did I go to
I
Copeland and Page and say, hey,
Well,
how do you demerge these? That's
that's-
not my jurisdiction. That's not something that as a zoning officer or a building official I would do. That's something that if your board believed it had the authority to do, as Mr. Watts suggests, maybe you have the power. I don't know. That's
See,
your...
one thing comes to me is that the application came through as a variance and changed to a special permit. And one of the tests of a variance would the action taken by granting the variance, would it nullify or substantially degrade for the intent and purpose of the protected bylaw? Well, if he came here with a variance, he'd probably get in trouble on that one, because that's what we're essentially looking at, is changing the intent and to nullify the purpose of. It's not a bylaw, it's a doctrine, so it makes it different, I suspect, but I don't know, I'm not a lawyer.
To be honest with you, I don't know the answer on this
Yeah.
one. All I'm doing is giving you the information that you requested. And again, I am not for or against the applicant's petition. I'm just giving information, and I would be withholding information if I
Okay.
did not give the information, and if I didn't tell you that other people in the neighborhood
All right.
have requested to demerge their
Okay.
lots. I have to
I
tell you.
want to thank you, unless someone else has,
I have a question. Could you talk to me a little bit about the process of merging lots and the reason for the merging of the lots?
Yes, Chapter 48, the zoning act of 1975, basically was set up to take substandard sized lots that were, in this case, it applies to this, that in 1922, all of these substandard subdivisions, because there was no regulations of zoning back then, so people just said it was an arbitrary, just cut the lot off. And what the state must have determined through the legislation of Chapter 40A was that, substandard lots don't cut it, people might be too close to each other, it's causing congestion. We see that down at the Whalum District, we see that down on the lakes, we see it down on the substandard lots. So what they do is they created Chapter 40 of the Zoning Act in 1975, and quite quickly, that says related a whole host of things, but related to the mergers of substandard lots, they said that as long as there is a lot in existence, and the key is in existence at the time that the bylaw changed that made it substandard, as long as it had at least 5,000 square feet and 50 feet of frontage, small lots like that. Most lots on the Whalum plans, which is got to be a couple hundred lots, don't even meet the 5,000 square foot standard. No. So what the merger doctrine said is, if you have substandard lots, you have two protections. The first protection is, if you have that one lot that is not held in common ownership with any abutting lot, lot to the left, lot to the right, lot to the rear, not the front, because that's your street. If you are held in common ownership with any abutting lot, then you need to have a minimum of 75 feet of frontage and 7,000 square feet for those lots held in common ownership. And if you have 10 of them in a row, like you see right there, you only have the ability up until 1981, January 1st, 1981, to build on up to 3 of them. As long as they have, if they're held in common ownership, 75 feet of frontage and 7,500 feet of lot area. So you'd have to take a couple of those lots, if not 3 of them, even just to meet that requirement. So what happens, they gave 5 years from the date of the Zoning Act, which expired in 1981, that said, now if you have substandard lots, you got to merge them, and your question is, what's the purpose? You have to merge them to bring them as close to compliance as possible, or bring them into compliance after you have to actually bring it into compliance with everything you got left. And after you build on 3 of them up until 1981, if the 5 that you have left don't equal what the bylaw is at that time, then that's just a parcel of land.
Okay.
The single lot exemption is lots not held in common ownership. I have a standalone lot. Lot 51 was a standalone lot because it was owned by a separate person than the Meisners next door at 49. So that was a separate standalone lot. When they purchased it, they kept it out of common ownership by the trust, which we know through legal counsel that does protect it. And what happens is the town took that property possibly for tax title, which they did because we sold it. So the town owned it. The town didn't own 49, which was owned by the Meisners, so it never merged with any other lots. The town's lots would actually merge also, and town-held lots. And what happened was that lot gained its protection, the single lot protection. At the time 40A was written, no time period of 5 years you get to build on 3 of them. It's standalone lot, you need a minimum of 5,000 square feet and 50 feet of frontage. And that's a grandfathered lot until it is purchased by a neighbor in common ownership. Then the common lot merger doctrine, which we talked about tonight, immediately merges them the day they buy it. The day that the Meisners got rid of the trust in 51, went in back common ownership with 49, the day they signed that document is the time in which those merged. They merge immediately. So if you have lots that are held in common ownership, they've merged. You can have 2 separate deeds. People sell a deed off here and a deed off there, believing they have 2 lots because they have 2 deeds. You can have 5 deeds representing, and there's a lot of them. Don, your house has 2 deeds, 2 lots, right?
That's a long time ago.
Right? But those, you can comprise a lot, because the purpose of the zoning act was to bring substandard lots. If you had the ability to use a lot that you held in common ownership with yours, then the common lot merger doctrine says you need to suck it into your lot for zoning purposes and bring your lot that you have a house on closer to compliance or into compliance before you can use any of the additional land that you have with it.
Okay.
And that's the purpose of the merger in 40A.
All right, so if
Bringing people into compliance.
All right, so if I understand, right now, lot 49, as it sits, as if lot 49 does comply with the 50 feet and 7,000, 50 feet of frontage and 7,000 square feet?
Yeah, currently, yeah, it
And
does,
lot
currently,
51
currently.
And lot 51 would also?
And 51 would also, although lot 49 actually belonged, because of the common lot merger doctrine.
I understand that.
But it's protected now because the town didn't do anything about it because we weren't aware of it, and after 10 years, you get the protection. So 49's protected. History's history. Don, you're right, probably happens a lot, and probably happened a real lot years ago.
It
And,
did. I have no reason to be the first in line to separate them again and create two buildable lots. I'm perfectly satisfied with the merger. So otherwise, I would recuse myself from this meeting, when you think about it.
All set?
Mr. Spaulding, can I just make one comment?
You please.
The commissioner did make an accurate rendition of the assemblage of the lots, which he identified as 37, 49, and 51. The house number 37 consists of lot 13, 14, and 15.
Right.
That was purchased by the Meisners in September of 1996. The house that is referred to as number 49 consists of lots 16 and 17. That was purchased by the Meisners in May of 1999, and it came from a different source. So they did not purchase those 5 lots at the same time on the same deed. And then lot 51, which is lots 18 and 19, were the lots that were purchased in 2003 from the town of Lunenburg. So it's a little bit different than perhaps the folks across the street who've purchased the 5 lots simultaneously and now would say, golly gosh, we'd like to dump 2 and make a building lot.
Yeah.
The circumstances we presented are a little bit different.
Understand.
Okay, any further discussion?
Yeah, I have another question. Can you, one of the things I was curious right now is that I have two separate lots. You're looking at having 2 separate lots. The reason why 49 and 51 were merged in the first place, was that a refinance?
Yes.
Okay, so can you step to the mic just so that you can?
sorry.
Right.
Yes.
So that was for a refinance?
Yes, sir.
Was it because to qualify? I mean, I'm trying to understand the reason why that it was done. Was it to qualify for the loan, or, you know?
We had used a credit union, and we've just recently found out that a credit union wouldn't accept a trust. It had to be held in our names. And
Okay,
at the time, when we were signing all that stuff for closing, we missed it. That's why we're here tonight.
okay. Now, so you're looking to split 49, 51. Can I ask that right now, how is the credit union handling that? Have you spoken to the credit union and how they're handling breaking this up?
No, sir, I haven't. We just made the last payment in June on 51. We financed a pretty good chunk of it. And the mortgage, well, I haven't approached anyone in regard to that.
Okay, so that's one of my questions is whether the mortgage company will allow you to demerge the 2 lots in order to, and are you still going to be able to satisfy the loan?
51 is paid for.
Yeah, it's 2 separate mortgages that we had. I'm Diane Meisner.
Understand.
It was 2 separate mortgages that we had. One was on the land and one is on our house.
Okay, so I guess the question that I'm still running into is that the reason for the reason for the merger was just because the credit union would not allow a trust to hold anything at all?
On our house. We were refinancing our house and they wouldn't allow a trust on our house.
So was there, I'm trying to understand, was 51 under a separate trust?
No, that was, no.
It's under the
Only
same
our
trust.
houses was on 49 Jocelyn, which our house is located on, that had the trust.
Okay.
51 was separate.
So 51 was, okay. So 51 was in your name, and it was just a lot in your name?
Right.
49 was under the trust?
Right.
So I'm still trying to understand why the credit union had to merge the two lots.
They didn't, as far as I knew. They didn't have any idea about 51, because they were two separate. When we went to refinance our house, 49 Jocelyn.
Yes.
That's the only thing that we refinanced. Had nothing to do with our land.
So I guess my question is what, have you found out why it was merged in? Why was, who determined?
We weren't sure of the law, and when they said, you can't refinance your house if it's in a trust.
The bank wouldn't lend to a trust.
I understand that the bank wouldn't lend to the
So
trust.
we had to take our house out of trust.
I understand that, so I'm trying to understand why 51 was thrown in there.
I don't
on
know.
you.
Because that was
It
not in
was a
the
separate,
trust.
no,
No,
that
it
was a
was
separate
separate.
purchase and sale.
Yeah, it's a separate mortgage.
Matter of fact, we were here. This is where we bought it, in this room.
Was it I'm sorry, go ahead.
What happened was, I can understand exactly what they said. It's the zoning doctrine that merged it, not the bank.
Right.
The signing of it, bringing it in common ownership, which nobody would have thought at that time about the merger doctrine, not the bank and maybe not the Meisners, right? I'm on a board of directors at a credit union, and you can't lend money to a trust if you're a
Okay.
credit union, that I know.
Okay.
So I just heard this for the first time tonight. So basically, they held 49 in the trust that kept it separate from 51.
Right.
51 refinanced, or however they did what 51 was out of the equation as far as the credit union was concerned. When they went to because I can picture what's happening, when they went to the credit union to refinance their house, they said, oh, you can't refinance because you're a trust. But if you put it back in your names,
Yeah.
then we can probably give you the money.
Gotcha.
So when they did that, the bank wasn't aware of 51 or the merger doctrine.
Right.
They probably weren't aware of the merger doctrine because they properly subdivided it out at the beginning. They knew they had to keep it separate. So, okay, put it in the same name, and they signed. So when they signed is when the common lot merger doctrine out there,
Before the
right,
ink
in the
dried.
cloud, said, now you merged it.
Before the ink dried.
Before the ink dried, well, before it dried, as soon as they were done signing their name, right, they merged for zoning purposes
Without ever knowing it.
with the bank not knowing it, possibly with the Meisners not knowing it, with me not knowing it. Nobody knew it until somebody came in to get a building permit, and now with the more knowledge that I have relative to zoning, after 12 years, show me the documents that it hasn't merged with any abutting lot. And when that got surfaced, unfortunately, I have to say, because it is unfortunate, so I'm sorry, I can't give you a building permit, you need to seek relief. It's the zoning, the merger doctrine merged it,
Okay, understand.
not the
Yeah.
bank.
You know, can I say, all our money is sunk into this lot of land. My husband has been unemployed for almost a year now, and we have a buyer for this. If we don't sell this, we're gonna have to file bankruptcy.
No, I understand.
This is our only-
I was just, and please, I'm trying to understand just what the reasoning for why this happened, because I heard the trust, I heard this, I'm hearing that it was based, and I understand when you're saying that, look,
Everything in this
nobody,
land.
you walked
We
in.
can't sell it, we've lost everything.
Right, I understand. So, I mean, basically, I understand, and I'm just trying to understand better why it was merged.
And we had no representation at the closing, we just, never even thought about it. At the refi, yeah. I signed a lot of documents.
Okay,
Thank you.
all right.
Fortunately, we had no
That was a long explanation for the word inadvertently.
Any further questions?
So the other question now is I would like to have, if we had a letter from the sewer commission on how they would like to treat 51. So obviously, there was no abatement made at that time, okay? A betterment made at the time. How is that how's the sewer commission looking to handle that?
I don't speak on behalf of the sewer commission, but I can tell you this. Before a building permit gets issued, and this is where this got picked up, the sewer commission has to be one of the several sign-offs.
Right.
So when somebody signs off, then everything's approvable. Well, they're not going to sign off if they don't believe, for zoning purposes, it's a viable lot. Because what happens when somebody wants a sewer connection or going to connect to their land, the sewer commission administrative assistant, Barbara, sends to me a sewer application that basically I have to sign that says it meets zoning. And lots do get sewer connections because they comply with zoning, and it's an automatic signature. I review it, yeah, you're all set. And lots that do not comply with zoning, as in this case here, I can't sign off on. I can't say that it meets zoning because it doesn't. We heard that tonight. Nor can I issue a building permit for something that doesn't meet zoning unless it gets relief. Now, every time your board gives someone relief, we put in the file, ZBA approved, special permit, because if somebody goes back, like a bank goes back years later, after they go to sell their property, they see that everything was proper, and your blessing of a situation like this, if you so desired to do that, makes it okay for zoning purposes. So I would assume that if you were to grant this, the sewer commission would say, they're legal beagle as far as zoning goes, because I'm going to state that it is, because they got the relief, and they would get the sewer connection, and the stub would go in after the fact if it's not already there.
Right.
That's how it...
My question would be more for the betterment. Is more, is that basically every other lot in that area has paid in a betterment to get...
They would pay after a better, from my understanding, Steve, you know this, you were a sewer commissioner, I mean, I was, but you were more a commissioner. Formally, it becomes a privilege fee after the fact. So if you did not receive a betterment when the line went by, and the town would have no reason to give themselves a betterment for 51, they're not going to charge the town. But when it got purchased, up until the time, there's no stub. It got purchased in 2003. The sewer went by in 2001. There'd be no reason to have a stub there or a betterment assessed. So when Barbara researched it to find out possibly if there was a betterment assessed to it, was it a legal lot, before coming to me, she found it first. So what ended up happening, what would happen is, if you give relief, it now becomes a privilege fee, which is pretty much equal to the betterment cost. But it's after the fact, so it's not a betterment, because the betterment's assessed across the board for all that are on the sewer line. When the sewer line goes in, the privilege fee is for anybody that taps into the line after the sewer goes by. He would get a privilege fee if the stub's not already there. If the stub was there, there would be no betterment, because the town wouldn't assess itself a betterment, even though they put a stub there, and they probably had no reason, or maybe there is a stub there, I don't know. But the fact of the matter is, he would pay a privilege fee.
The planning said there is no stub. Is that correct, if I understand that correctly?
I'm not sure.
That which raised the flag from the sewer board.
Yeah, if there's no stub, she must have been looking. If there was a stub there, they'd probably say, well, I guess I would have just received the paperwork to sign off for compliance. If there was a stub. Because there's no stub, Barbara's like alarmed, like, bing, bell goes off, how come there's no stub there? Then she goes and looks at the registry. The town owned the property. Well, the town's not going to develop it. And maybe when the line went by, they just said, hey, no stub. And if somebody wants to make it a buildable lot at some point in time, you pay the privilege fee, which is basically a betterment. That's how it works after the fact.
Thank you.
So if you were to grant this, it would be okay for zoning purposes because it got relief, and I would sign off on it for the sewer commission.
So I guess the question then is, who would pay the privilege? Would it be the new owner, or would it?
Well, that would be between the owner and the buyer.
If we read thoroughly the purchase and sale agreement that was part of the application,
Yeah.
The
Okay.
buyer...
I'm
the-
just trying to clear.
The
Thank you.
buyer, the buyer said the owner has to take care of that, as I recall.
In the PNS, yes.
Yes, in the PNS.
At the foreclosure auction, prior to the auction and post-auction, it was implied that the betterment fee would be absorbed with the purchase price at the time of auction.
Oh, and you have that documentation?
No, sir, I don't. Nope.
That's why you said implied rather than...
Implied.
Okay. Pay attention to signing, huh?
So that's a problem in itself.
Okay, further questions?
Yeah, no, I understand, I just was...
Any further questions? If not, the chair is ready to accept a motion.
I have a comment rather than a question.
I was going to say, I have a comment. I truly find this a unique situation. I find it, I don't think there's any fault here. You have to have sympathy for what's going on and the fact that, it came out of the trust, it merged. My concern is, even though it's a unique situation, does it lead to a lot more other unique situations that come in? My only concern, or my only question is, I still question how we demerge the two lots, and I'm just wondering if maybe we shouldn't at least check with Copeland and Page and get an opinion before we make a final ruling.
I would think that that's probably appropriate in view of the fact that I have all the compassion in the world for the issue and how it happened, that in the spontaneous time of 2 minutes or 3 minutes, everything gets turned around. If they were a corporation, it would seem to me that the decision could be easy, the tough decision could be easier to hand out, in the opinion. Yeah, but it's a Pandora's box. But, it questions in my mind, is this the proper venue to relieve this? And I'm not sure that under the simple bylaw that gives dimensional variations for the guy who wants to go up 2 more feet in elevation or 6 feet in side yard, which is where that special permit for dimensional variation came from. And it was to sidestep variances, and that the variance, if that was what's on the table today, a no answer could come along pretty easily. So I have all the compassion in the world, and I would think that, and for the applicant's benefit, because if we don't do it legally right, if this is the improper venue, or we don't have the power to do it, but to get to our attorney to say, hey, you can do it, then so be it. So that's why I have that feeling.
That's why, that was my concern, is that if we do it improperly, it's not going to do anybody any good.
Well, I guess my comment is in looking at this section that grants the Board of Appeals these powers. I think I can hear the echo.
You can hear your Don can.
Let me crank up the hearing
Crank
aid.
that thing up.
They got me last week because they make me stick it in my mouth.
It seems to me that the wording of this does give us the power to grant this dimensional variation. I was like the discussion here a minute ago, I was confused by this doctrine of merger and demergering, but I don't think that that's the issue. It seems to me that the sticking point in my mind is the long-term view of what the purpose of our current zoning requirements are, which for residential A is 40,000 square feet and 100 feet of frontage. Well, all of these lots, when I went down through there, the 4 streets, I forget, Otis Street, and, you go through any of those streets, and those houses are close together, so it comes out of that 1922 plan, and we have many situations similar to that in town, and we grant dimensional variations for many of these lots, both for frontage, setbacks, any number of things. And I've not felt uncomfortable with being a member of the board that can grant those requests for a special permit. Prior to having this provision in our bylaws, I thought that variances were, in my opinion, next to impossible to grant if you followed the letter of the law. So I felt very comfortable with this new provision being added. And from my perspective, I think that considering what had transpired with the Meisners, I feel comfortable in looking at some of the houses in the rest of that area that we can grant that special permit. So I'm not uncomfortable with it.
You mean,
But you grant the special permit to create the lot.
No, I'm not granting special.
But you got to add in the decoupling of the, in other words, do we have to speak to the issue?
Why? Is it, what's
In other words, do we have the power to break the merger doctrine? And in the write-up, if you were to approve, say that by this document we decouple or we break the merger doctrine? Because that's what's on the table, the merger doctrine, not the dimensional variation. The dimensional variation, we say, okay, we grant you this dimensional variation, which hasn't changed, and yeah, you can have that. But that connection, it's got to be broken by the same document to free it up to be able to do something with it, I think. And I could be absolutely wrong. And I'm open to discussion from my perspective.
Mr. Chair, if that's your concern, should we continue this based on getting a ruling from a legal opinion from Copeland and Page? As simple as that.
I'm beginning to think as this is opening up, evolving, and there's compassion here. There's a lot of issues sitting here on the table that maybe we need to speak to the issue through attorney, I think.
If that makes you feel, I mean, if that's going to help in the decision, that I would move that we continue.
Question is, do you have the same concerns that I do?
Actually,
maybe
no.
You don't.
I look at this as that the town sold them a buildable lot, that this happened inadvertently, that if you look at it,
when the town sells, they don't attest to anything.
They basically sold them a buildable lot.
No, but they carefully, when you go up to the bidding, they carefully say that they make no claims to what you're buying at auction. I don't think that you find a document from the town that says that's a buildable lot. But it does remain buildable based on, for zoning purposes, based on what Mike has said. So whether is it buildable, the answer is yes, but the town didn't make the declaration. As a matter of fact, the town shows it as...
I'm sorry, the building inspector.
The town shows it as, when I went to the assessor's office, as non-buildable, and it pays $17 a year. Go ahead.
Mr. Chairman, when I was in the room during that auction, and coincidentally, I was sitting right next to my friend Steve DeBettencourt here, and I can remember that auction very clearly. And Steve just refreshed my memory, and I'll tell you in all honesty, I remember the question being asked. When the auction went off, Steve and I were sitting in the back corner right over there, and Kathy asked me, is it a buildable lot? And I said, for zoning purposes, because of the 40A, yes it is. I stated that.
Okay.
So, just for the record, I gotta tell you all the facts that I'm aware of. I stated at that time, If it wasn't a buildable lot, no one would have paid $81,000 because that's what buildable lots were going for at that time. And keep in mind,
Might have been a bargain at that time.
when they did the trust, it was still a buildable lot.
Yeah, well, that's what I had concluded, that for zoning purposes, it was still buildable, but
So it was advertised to them as a buildable lot?
well, now that he comes forth
Right.
and says it, if I was Judge Judy, I'd say that's hearsay.
I don't know if that was recorded or not, but
It'll be recorded somewhere, yeah.
Yeah.
keep in mind.
It's recorded in both Steve's and Mike's
Well, I
memory.
was gonna say, it's not his testimony, he testified to it.
Okay. Anyway, moving on.
I have a further
Go ahead.
further comment.
Read Mary, yes.
I think that in granting a special permit, one of the things that we always read into the record is that it's granted with the contingency that the petitioner comply with all licenses, regulations, statutes, and ordinances of any and all applicable state, local, and federal boards or agencies. And so I think that that covers your concern, at least in my view, because as we've heard, this was a buildable lot when they purchased it, and it seems from the discussion that it was the credit union which created considerable confusion about.
Yeah.
It sounds like they basically still have two separate pieces of property, one in one name and one in another name,
Well, now it's
not
both their names.
merged together, other than
Well,
that.
Actually, if they
That's
kept
my
it one in one name, one in the other name, we wouldn't be sitting here. Right. So
Variation to
can we entertain a motion?
half of it.
I'll always entertain a motion.
All right, I'd like to.
That way I don't get myself in the trap, but someone else does, not me.
Right now.
I'd like to make a motion that we allow the separation of the two lots, and that allow the separation of the two lots under the understanding that these lots were sold to them that this was an inadvertent mistake, and these lots was sold at different times, and it was sold to them as a buildable lot by the town. Did I say anything? That we grant?
A second.
I would object to one thing in the seconding, or in the first place, is that to say that the town, from hearsay, Judge Judy Albino, is, it said that this is bona fide and that is a buildable lot. Independent of what Kathy did when at the auction, the building inspector says that it is a buildable lot. And so for purposes of zoning, and if that's true, then if you'll amend it to include that.
All right, I'll amend it to.
Withdraw the
I'm
hearsay.
sorry, go ahead.
I want to, for the record,
Yeah.
that's what happened back in 2003. I do recall, as Steve mentioned that. Keep in mind, in October, the Meisners received a letter from me stating that because of the trust, it was held in separate ownership. It was a standalone lot. Before I wrote that letter, I called Copeland and Page, told them the circumstances. I told them that Dave Meisner was a trustee. I told them that, because I had not known about that the trust had dissolved, and it was represented that it hadn't. It was dissolved because it was dissolved inadvertently. So I asked Copeland and Page that if there is a sole benefactor of the trust, even though the husband's the trustee, is it common ownership? And he said no. He said, actually, if you have two benefactors and only one benefactor owns the other lot, it's still separate ownership. So at that time, when I sent the letter, and forget what Kathy might have asked, you're right, that's hearsay because it's not in writing, and if it wasn't on a videotape, which we know it wasn't, it's hearsay. You're absolutely right. I recall it. Steve brought that to my attention. He goes, Mike, remember when we were sitting in the back, they asked you? And I said, yeah, you're right.
Yeah, he's hearsay too.
And he is too, right. But the bottom line is,
No, but your statement is what I would...
forget all that. Look at my letter in October. It was a buildable lot as long as the trust wasn't dissolved, and that's what you're discussing today. And if it was inadvertently dissolved, then it wasn't done intentional.
Amend you amend it just to say that it is for zoning purposes, it's buildable.
Okay, so I'll amend it to say for zoning purposes, it's buildable.
Go ahead.
Coming in.
You're welcome to talk.
Can I make a suggestion?
We'll invite anything that no, I didn't mean it that way. Any good comments?
A suggestion. Along the lines of the motion that is on the table, that basically you find that it would be appropriate to disregard the 2006 deed because of the circumstances under which it was done, and that a condition of the special permit would be that the title to the property be returned to the trust.
Are you writing, Lisa?
You bet I am.
The title of the property.
And that would, quote unquote, decouple.
Earlier, I grind inside on that one, but you're getting there, huh? Mr. Copeman.
Was that, no, we're talking about, which one of these?
51 is the empty lot.
51, putting 51 back in trust, is that what you?
51 has never been in the trust.
Right. But they have a problem, you can't put 49 back in trust because of the credit union, right?
Then obviously,
Correct.
51 would be in the trust.
well, that would sort of not track exactly how I had stated that.
I misunderstood, perhaps.
Would you put 51 in the trust before it gets sold to the builder, so it's demerged from 49?
As a condition of the approval of the special permit. Obviously, that could be done tomorrow. Because the mortgage, you told me the mortgage on 51 is paid off. There's no mortgage on 51.
Okay, where are we?
So I have a motion to grant the separation of the two lots. That basically just a motion to grant the separation of the two lots. I don't.
And I think that what Attorney Watts was suggesting is that we put a condition in there that by separating the two lots, that 51 goes into a trust. Is that correct?
Separate the ownership, I mean.
Separate ownership?
I'm just trying to keep it, I would like to keep this simple. I just want a motion to separate, to allow the separation of the two lots. And based on a misunderstanding in 2006.
I'd like some of the verbiage that,
I was gonna say. I
Lisa,
think
can
you
you
gotta get
construct
that.
what we're
I
at
think you're gonna get them in trouble.
in any way, shape, or
Well,
form?
the problem I have is that the
think
verbiage
that-
you're asking is that you're asking for this trust to be established on the property that can't have a trust on it, right? 49 right now cannot have a trust because it's owned by the credit
Correct.
union.
And there's a mortgage on it.
And there's a mortgage on it.
So 51
No,
is owned
there-
outright by the
there-
applicant.
There is a provision in a mortgage. If you look at the standard Fannie Mae mortgage, at the back of it, it says that the property may not be alienated, and there's some exceptions listed. And essentially, if you create a trust where the mortgagors, the husband and the wife, are the beneficiaries of the trust, you can do that. You know, when the trust police or when the mortgage police drive by, that's not offensive to them. So there is a mechanism that I've often recommended to people, just saying, you know, we have it in a trust, the bank wants us to put it into our names to get the mortgage, and then after the fact, you put it back into the trust because it doesn't offend the Fannie Mae requirement. And again, you're on the board of trustees of the credit union, but that is a standard clause that the page 26 of the standard mortgages, and also the promissory note.
Yeah, so you're saying that 49 can be put back into a trust?
I would say, I haven't looked at,
Never was in a trust.
I would say that you could put 49 back into the trust, and that would make sense.
49.
That you're reversing the inadvertent action.
Yeah, okay.
Okay, that's fine. So I make a motion that we grant the special permit based on the action of Lot 49 being put back into trust, and therefore not making any not having a joint ownership on both lots.
Can you give it your best shot to see if everybody agrees
Okay,
with
David
it?
Blatt made a motion to grant the separation, of the two lots based on, with the condition that 49 Jocelyn Street be put back in a trust based on the misunderstanding of a 2006 reversing the inadvertent action.
Thank
Kinda,
you.
sorta.
Yep, I like that.
Is there a second to the motion?
I second it.
Is there discussion on the motion?
Does that create a problem with the mortgage?
Based upon, I only have one copy of the
Is he it?
usually a provision in the promissory note that just talks about,
I guess it's mostly curiosity to ask questions. If we voted in favor of that motion as it was presented, why, that's a condition.
standard Fannie Mae document.
Pardon?
I would ask the clients to produce to me the Fannie Mae note.
I cannot hear you.
I'm sorry. This is a standard Fannie Mae document, so although I have not seen the note, I would think the transaction involved a standard Fannie Mae note, and one of the terminal paragraphs in there talks about, transferring an interest in the mortgage, and that's one of the exceptions under the Fannie Mae regulations. Basically, you can put it into a trust where the mortgagors, which would be the husband and wife, are the beneficiaries of the trust, which is the case that we've got here.
Oh, okay.
So that's the basis of the suggestion that
Okay.
I was
Yeah.
making.
Can you restate what we got here? Has any change?
Okay, that was the same state. Oh, it's just still sits.
Lisa's got to get it right to the,
Okay.
because...
Lisa will get it right.
Monday morning, he's going to say, what
Okay.
did we say?
That's fine. Go ahead.
So you've got written what we're going to say?
You want that one more time?
We-
I'm good.
Well, no, let's hear it,
Okay, David Blatt made a motion
because we got to vote. We're going to vote.
to grant the separation of the two lots, put 49 Jocelyn Street back into the trust based on a misunderstanding of the 2006 and reverse the inadvertent action. Actually, reverse the inadvertent action of the trust created in 2006.
Trust absolved in 2006.
Any further discussion? No further discussion?
I did, yeah.
The motion's made, seconded. Any further discussion? All those in favor of granting the special permit for dimensional variation as in order to, I'm looking for a good, relieve the problems associated with the with the bank, please say aye.
Aye.
I think, and I've never done this ever, is pondering abstention. If I abstain, it passes anyway. Abstention is a no vote, and you need 4 out of 5. I'm pondering. They've never done it. But if that was a large corporation sitting there, my answer would be different. I'm going to abstain for the first time in 30 years. So you get granted what you want.
Thank you, Mr. Bowen. and members of the
In spite of my abstention. I didn't say no, I said abstain. Thank you.
Don't forget.
Oh, wait a minute, I gotta read now. This thing went on so long. Okay, the good reading. It's a special permit. In granting the special permit, the Board of Appeals did assure that the proposed use would not be injurious or dangerous to the public health or unduly hazardous because of traffic congestion, danger of fire, or explosion or other reasons. That it would not have a material adverse effect on the value of the land and buildings in the neighborhood or in the amenities thereof. Your letters from your neighbors seem to support that issue. The other two is operating in reasonable regard to, that doesn't apply in this case for sure. And the special authorization is granted with the contingency that the petitioner comply with all licenses, regulations, statutes, and ordinances of any and all applicable state, local, or federal boards or agencies with jurisdiction over the premises. The granting of the special permit inures to the benefit of the applicant. There's more to it, but it doesn't apply here. The special permit now is subject to periodic review. That's the last thing that you need. But in construction, that would be applied. So you can see how this special permit is slightly off course, which was some of my concerns. Anybody can appeal the decision of this board to Superior Court within 20 days after it's stamped, which takes about 14 days to get it through Kathy downstairs. So they have the right, and then to advise you, which I'm sure you'll do, is to record it with the Registry of Deeds. And are we ready to adjourn this meeting? We'll take a motion to adjourn.
So move.
And
Second.
good luck. I'm sorry I had to do what I had to do, but in my heart,
Sorry, guys. My dog's standing outside.